First, thank you for tuning in. I'm Eli Suter with Suter Law Firm. I'm a virtual in-house counsel. I help business owners from entrepreneurs with startups all the way through to established business owners who are ready to start thinking about succession planning. I help them with a wide range of legal matters, many of which will be topics of videos such as this one. Here's what we're talking about today. But before we get into that, I do want to remind you that while I'm licensed in Arizona, New Jersey, and Pennsylvania, this information is not state specific. It's just general information, not legal advice, and you watching this video does not make you my client. Okay, let's talk business law. Okay, in this lesson, we're going to talk about buy-sell provisions and succession planning. And this can apply to LLCs and corporations and even partnerships, whether you have an operating agreement for an LLC, a shareholder agreement for a corporation, or a partnership agreement for a partnership, or you can also have a standalone buy-sell agreement. So first and foremost, right, here's the client. What are buy-sell provisions? What does that mean? What is a first right of refusal, sometimes also called a right of first refusal? What are tag-along and drag-along rights, right? A shotgun. What's a shotgun buy-sell provision? And finally, what is a succession plan? A lot of different terminology that we're going to be going through. I'm going to start by talking about some common buy-sell provisions that you find in, like I said, operating agreements for LLCs, shareholder agreements, partnership agreements, these closely held businesses that have restrictions on the transfer of ownership interests. So these are some of the buy-sell provisions you might find. The first most common is that first right of refusal or right of first refusal, and this is triggered by some third party is coming along and offering to buy out an owner, typically the majority owner because they want majority control. The right of first refusal gives the company and or the other owners, and sometimes it's the company first or the owners first, and if they don't exercise, then the other one gets an opportunity. But it is buying out the owner that has received that offer at the same price as that third party offer. It can be on the same terms. If it was an all cash offer, it may say that the company and or the owners have to come up with all cash. The buy-sell provision may also state that the company exercises their right of first refusal, they can pay it off over 5 years, right? It may make it a little easier to keep that third party out. So tag along. Let's say it's the majority owner is received an offer, majority owner controls the company, so now the company is not exercising its right of first refusal. The other owners maybe don't have the finances, the minority owners, to fund the buyout of that owner. Well, they can also say that if it's sold to that third party, the minority owners can tag along, right, and force the buyer to also buy them out. So the minority owner isn't stuck there with a new majority owner. And conversely, drag along is where the majority owner is sold. Maybe the minority owners don't want to sell, but that selling owner can't force them. He can drag them along into that transaction if there's a drag along buy-sell provision. Also, this is a shotgun. This is between owners. This does not involve a third party, right? And this is where one owner offers to buy out another offer, and that owner can either accept the offer or flip it and say, hey, you made a lowball offer to me. I'm going to flip it. I'm going to buy you out at that same lowball price per interest, per share, per percentage of interest. This can be a bit unfair if you have one owner who maybe is the majority owner or whatever that is much more wealthy and has more resources, and then if you have a younger, maybe not nearly as wealthy and doesn't have access to resources, that the one with the wealthy and the resources can kind of bully the younger, the one that's not so wealthy, and offer a lowball offer, and in essence force a buyout at a lower than fair market value price, because knowing that the weaker owner is not going to be able to flip the script on them and exercise the shotgun right to buy them out at the lower price. Next, I would like to talk about different type of buy-sell provisions that are triggered by certain events occurring, and these typically apply to owners who are active in the business. The first one is death. This buy-sell provision requires that the estate of the deceased owner accept the offer from the company or the other owners to buy it out. This would be typically funded by life insurance. It's paid for by the company. This is the ideal situation where you have enough life insurance to completely pay the deceased owner's estate for his ownership interest, his or her ownership interest in the company. You can also provide for payment terms if there isn't any life insurance, or if it isn't enough to cover the full purchase price of the, however the valuation is determined. And so might say, it can be paid out over 5 years. The same thing might be triggered by the disability. If an active member is disabled for 90 days, 180 days, whatever the owners all come together and agree is too long for somebody to not be active in the company and earning their keep, so to speak. This can be funded by disability insurance, again, paid for by the company. Another one that would trigger, not necessarily an active member, this could be an inactive member, but is the voluntary or involuntary bankruptcy of an owner. What it does is allows the company or even the other owners to make an offer and buy out that insolvent owner at a discounted rate, discounted book value versus fair market value, right? Considering whatever funds go to that owner are simply going to go into their bankruptcy estate to go pay their creditors. It can kind of make it easier for the company and the other owners to maintain control. You don't want the bankruptcy trustee coming in and stepping into the shoes of that owner that's insolvent and has gone into bankruptcy and participating in the management of the company in any way. So finally, retirement. This is when an active owner wants to exit the company prior to passing away. And this is what we're going to get into next, which is succession planning. Succession planning, right? Buy-sell provisions are, in essence, a type of succession plan that are triggered by certain events, third-party offers, death or disability, something like that. What we're talking about now is more of a proactive exit strategy for an owner who's ready to move on, right? They retire or maybe go move on to a new business challenge. They've built this business up, it's success, and now they're ready to go try something new. Having this succession planning in place can add value to your business when it comes time to exit. You want your business to be as valuable as possible. It's important to be proactive when it comes to your succession plan, but it's better late than never. So get started today. Start by gathering your financial documents and cleaning up all the company's books, making sure everything's clean. You want to be able to hand over a turnkey operation, basically, right? That runs smooth. Think about it, put thought into it, put it down in writing, and when you implement it, you're going to identify people that are potential people to take over, and you're going to start grooming them, right? Start getting them ready to take over management. So what are the different types of succession plans? Here's a common type. One is obviously selling to a co-owner. This could be done, with that shotgun buy-sell provision, or it could just be negotiated. Maybe one day one owner wakes up and says, "Hey, partner, you want to buy me out? I'm kind of burnt out. I'm done." Another one might be to pass the company down to family members, right? Somebody before your death, they've been active in the business and they're ready. You've been grooming them and they're ready to take over. There's different ways that you can do this. Let's say you have an LLC or an S corp, whatever it is. Each year you could gift a certain number of shares, non-controlling, non-voting, however you do it, to these family members. You could do it to your heirs that aren't going to be active as well. If you have like a family member that's going to be taking over and the other family members still want to retain some ownership. So there's a lot of different ways you can structure that. If you don't have a family member or co-owners who are ready to step up, you start looking at your key employees. Who's your top manager? Who do you feel most likely would be able to step in and take over management of the company and take over ownership and continue its success? Obviously, selling to an outside third party. If you're doing this, being proactive means more money, right? Like we talked about, you want to get everything in order. You want to turn over a turnkey operation. You want to have solid management in place. Maybe that management isn't able to step up and become owners, but they're willing to stick around after you sell the company. That's a huge selling point, right? If there are multiple owners, perhaps you structure it so that the company absorbs that interest back over time or redeems that owner's ownership interest. With all of these, the key question obviously comes down to financing. When you're selling your company, you're getting bought out of a company. How is that structured? Is it that the company's just going to owe you money over 5 years and pay you off over 5 years? Even if that's the case, if you're selling and you're carrying it, it's called carrying back the purchase price. You want to make sure you're using a secured promissory note. When it comes to being in a bankruptcy situation, secured creditors are way preferential treatment to unsecured creditors. You don't want to sell your business that you've spent years building to somebody on a unsecured promissory note and then have them make 3 payments and go bankrupt, and then you're done. You've lost everything. You have no rights as a creditor almost. Versus if you're secured, what is that promissory note secured by? Maybe it's secured by the interests that you just sold, so you can foreclose and take your interest back. All right, now you got your company back. You could also or secure them with the assets of the company, so that you could then go at least get the assets back. So there's different things that you can secure it with. Maybe the buyer has a home that they own free and clear. You might do a deed of trust or a mortgage on that home and secure it with their home, right? Then they're going to be motivated to make sure that they're paying you. That's the idea. Ideally, you're not carrying this purchase price, right? The best case scenario is they're going to get a bank loan or an SBA loan or something like that, and you're getting cash at closing. Cash is king. So there you go. Thanks again for tuning in. I hope you enjoyed that short video, or if you didn't enjoy it, you at least found it informative. My name is Eli Sluter. I'm a Sluter Law Firm. I'm a virtual in-house counsel mostly to business owners and real estate investors. I help with a wide range of business and contract matters, anything from non-disclosure agreements, independent contractor agreements, buying and selling businesses, things like that. Estate planning, I can help anybody with estate planning, but it's especially important for business owners to have an estate plan in place early. Succession planning, that includes buy-sell provisions or standalone buy-sell agreements. Asset protection is something that applies to everything that I do. Real estate, anything real estate and related, whether it's residential, commercial, whether you're buying, selling, or leasing, and if you're leasing, whether you're a landlord or a tenant, I can help. Finally, trademarks. I want to make sure that the brand that you are putting all your blood, sweat, and tears into building is something that you can protect and that isn't infringing on somebody else's rights. Like with everything else that I preach, it is very important to remember that an ounce of prevention really is worth a ton of cure. Why do I preach that so much? Because I've seen the ton of cure too many times. So please give me a call sooner rather than later. I'm happy to help you. All right, thanks again.